Good afternoon, everyone, and welcome back for our afternoon panels. Our first panel actually have 4 speakers because our first paper is going to be co-presented. So the panel is on from use to registration, whether or not this is a paradigm shift. For the first paper, we'll start with Dr. Carys Craig from Osgood and her co-presenter, Dr. Bita Amani from Queens. They'll be speaking on whether trademarks are in transition.
Okay. Hello, everybody. It's just lovely to be here today. Bita and I are just delighted to be joining this discussion, and we want to take the opportunity to thank Teresa and Florian for their organising, and thank you for being here. And we're especially pleased to be on this panel dedicated to discussing trademark use and registration, because it's something we've been thinking about for quite some time now. Is that okay? Is the microphone a bit buzzy? We're okay? Just checking. Okay. So the paper, the use of trademarks in transition, has had a bit of a gestation period now, as we've been kind of eagerly awaiting regulations and for the amendments to come into force. And we now realise that that whole exercise of waiting was a bit like waiting for Godot. We think we understand it's still going to happen, but we're drawing a couple of implications or inferences from this delay. So first is that we should probably stop waiting and just publish this paper already. And secondly, and more importantly for your purposes, is that we think that the original position that was taken by government, that the changes we're anticipating were merely formal and would have little substantive effect, is perhaps being somewhat rethought. And if that's not at least a reason for the delay, it is an opportunity, we think, that's born of the delay. In other words, this would be good news, especially given the rather stealth manner in which the amendments came to be. Despite all this waiting, the paper is and remains a work in progress, and so we are genuinely interested to hear your comments. Our ultimate objective is to take a sort of theoretical and hopefully also a comparative approach to demonstrate what we see as the principled incoherence of the proposed system, its constitutional inconsistencies, its potentially resultant inequalities, and also its practical implications. So you can see why we're not quite done yet. Hopefully we'll get there. But the main point is that we think Canada is currently teetering on the brink of a very foundational change, and we want to situate that discussion within the broader global trajectories of trademark law and think about the broader critique about the changing role and the shifting nature of trademark protection. So in the first part of the talk, and with apologies for those of you who know this stuff, I'm going to run briefly through some of the key aspects of those impending changes to the registrability of trademarks. And then I'm going to try and situate these changes within the sort of historical and judicial context. And I'm going to pass things over to my colleague, Dr. Bita Amani, who will be talking about the constitutional trademark narratives, and then rounding things off with some thoughts on the international trajectory of trademark protection. So we're assuming that everybody here probably knows a lot and cares at least a little about the changes that we're awaiting. And we hope that at the end of this panel today, we'll all have had an opportunity to talk and think about the way in which these changes might be implemented more thoughtfully, or indeed preferably reconsidered. Okay. So I'm just going to talk briefly about the transitions that were taking place in the Canadian trademark landscape in the sort of lead up to these changes. So the years preceding it were, of course, tumultuous ones. We had several important developments that culminated in the passing of the Economic Action Plan Act, or the budget bill, about which we've already spoken this morning. First of all, there was the introduction of Bill C-8, the Combating Counterfeit Products Act, implemented in early 2015. There was the commencement of ratification processes for international treaties like Nice, Singapore, and most importantly now, Madrid, and of course the passage of Bill C-31, the Budget Act. It just so happens that Bita and I also owed a second copy of our trademarks textbook right around the same time. So that was not ideal. This is just a note to self for next time. We would probably have held off. It wasn't a good time. We had to grapple with two different but overlapping pieces of amending legislation. It was like doing some sort of crazy statutory jigsaw puzzle. And we also really had to perfect our grasp of the future conditional tense. I don't think we did it very well, and nor did our editors, but there you have it. And of course, all of this happened against the backdrop of the negotiation of the EU-Canada Free Trade Agreement. So we know on the trademarks front that the agreement is actually quite cursory, but it does include this clear commitment to joining the Madrid Protocol. So this provides the context, if not, we think the genuine motivation for the amendments that we're focused on today, which will, for the first time in Canada's history, permit the registration of trademarks in the absence of any actual use of the mark in commerce. And the Budget Act was explained to us as a way of allowing Canada to catch up, quote, or to come into line with the world and adhere to the Madrid Protocol. And when we presented this paper last year at INTA, the lawyers in the room were surprised to hear that Madrid purportedly required the switch from the US-like use-based system to a more EU-like registration system, especially since the US is a Madrid member and a stalwart use-based jurisdiction. But that seems to be what the Canadian trademarks community was being told. In fact, the treaties, of course, impose no obligation on states to change domestic registrability requirements. But nonetheless, we're poised on the brink of this major fundamental shift. Okay. I was going to say something about the whiff of regret in the Ottawa air, but I don't know if anyone else can smell that. We have the sense, and I've heard rumours, that there is indeed a whiff of regret in the Ottawa air, that these amendments are going to become law, and maybe a little bit of mobilising around it, because so far we were told that they'd be given effect in 2016, then 17, then 18. We now have it on good word from the street. Bay Street, that is, that it will be 2019 if you believe what Bay Street lawyers tell you. No offence to Bay Street lawyers, you should always believe them and pay them handsomely. Okay. So Canada is, of course, a use-based trademark system. Its origins lie in common law Britain. Common law passing off protects indicia on which the plaintiff has built up a reputation and goodwill through use. Trademarks are protected at common law and under the federal legislative scheme. As Justice Ritchie explained back in 1888 then, it is not the registration that makes the party proprietor. He must be proprietor before he can register. Currently, in the Act, trademarks are defined in terms that presume use of the mark in trade or commerce. Use is given a technical definition in Section 4, which you're probably familiar. And we'll just very quickly rattle through the current doctrine of entitlement to register. So under Section 16, there are three bases on which to claim entitlement currently. One is use of the mark or making known of the mark in Canada. And if it's just based on a mark being made known, it must be well known. And in order to be well known, it must have been used in a country of the Union. This was our implementation of Article 6 bis of the Paris Convention. Then you have foreign registration and use as a ground of entitlement under Section 16(2). So again, it's based upon the foreign registration, but the mark must have been used, albeit abroad, if not in Canada. And then finally, we have proposed use, which allows for applications to be filed on the basis of a proposed use, establishing a priority date that can beat out a subsequent user, even a first user. But this ground does still rely on use, however, because the application may be allowed, the entitlement date set, but the registration won't be granted until there is use and a declaration of use filed. So to be clear, and admittedly, this is not a pure use-based system. It is a mixed system, but it is one in which the centrality of use is very clear. So in order to obtain a registration for trademark in Canada, it must have been used somewhere in commerce, and if not at the time the application is filed, then certainly by the point of registration. And so As Paul Tackleberry here explains, because trademarks are symbols of source and quality, they don't exist in the abstract, but only in the marketplace. And some might think this was overstated, but we agree that the Anglo-Canadian system up to now sees use as effectively the threshold requirement of protection of trademarks. So it occupies a role that's really roughly equivalent to the originality doctrine in copyright law. Just as the doctrine of originality determines authorship in copyright, and so it's the sine qua non for copyright protection, use is what allows a trademark to perform its communicative function, communicating source and quality in the marketplace, so it's the sine qua non of trademark protection. You might say use is what authors the mark, and it's what authorizes the private enclosure, the entitlement that registration brings. So the centrality of use, then, I've said, is relinquished in the impending changes to the Act. The new Section 16 includes a single basis of entitlement that any applicant who's filed an application for the registration of a registrable mark is entitled to secure its registration. In other words, the new basis of entitlement to register will simply be the filing of an application to register. There are a few caveats. So prior use will still have priority over an application, but applicants don't need to state, but applicants don't need to state a date of first use in their application or whether the mark has ever been used, so it's actually going to be really hard to know whether you have a prior use claim that you could bring to oppose a mark. And then there's an additional enumerated ground of opposition that the applicant wasn't using and didn't propose to use the trademark in Canada. But it's unclear on what basis you would actually be able to show an absence of an intent or a proposal to use. That seems a very subjective intention. Proving the negative is going to be very challenging. And also, of course, you're still going to be able to expunge the mark after 3 years, but that's going to require a proactive procedure that costs time and money. That's expunged after 3 years of non-use, to be clear. So I'm going to speed up and take another minute just because I need to pass this over to Bita, and I don't want to use up all of her time, or she'll probably never speak to me again. So let me just see where I can leap forward to. Okay. Our point here is that a trademark should be used in the course of trade, and that there's something inherent in the idea of use that defines what a trademark is, and there always has been. So I was hoping to stop on David Vaver since he's here. Did I skip over you? Did you see your photo already? No, it's coming up.
That's all you.
That's all me.
The fact that this is still in.
The oldest mark in use. Okay, it doesn't matter. Okay, so let me just jump forward then and say that this is the story we tell ourselves about how we justify trademark, why we protect trademarks in the marketplace, because they communicate something to consumers. And in order to communicate anything to consumers, they must actually be used in the marketplace. And this has been the story that the Supreme Court has repeatedly told us as well about why we protect trademark and what the limits of trademark protection should be. We've been told that the gravamen of trademark entitlement is actual use. So that's when we're talking about the protection of trademarks as being not about protecting the trademark as a thing itself or as a piece of property, as Professor Vaver said earlier, but something that encourages trade, free and fair trade. And so these and many other cases demonstrate the judicial attitudes that help to rationalise and shape trademark protection. And what we're asking you to do here is really to query whether these judicial rationalisations can stand with the proposed law reforms. How will the courts explain the operation of a system that has largely abandoned its formative rationales? Okay, you're up.
This presentation, it will be speaking a lot about the use, the juju, the oju, all of that stuff. So if you want clearer distinctions, just read the paper when it comes out ultimately. But we've been talking here about new directions in trademark law. Are these registered marks really going places? Are they going to the market? Will they ever be used? And well, there's a single clutch, we have to stall and think. The single clutch, I think, would have been just the federalism question on its own. I think this merits more of a double clutch because there's both a federalism question and there's a freedom of expression question that I will look to get into in this part of the presentation. You've heard Carys talk about the use of use, what its utility is, what function it performed, and legitimizing the system as a whole within our constitutional scheme is the question that we'd like to look to at this point. How can Parliament and ultimately the courts justify the nature, scope, and enforcement of rights that are acquired under the Act in the absence of use or acquired distinctiveness and goodwill? How will the federal government justify the exercise of the power to regulate trade and commerce in the absence of any actual trade or commerce? Civil remedies such as injunctive relief were originally provided early in the 19th century in respect of the common law tort of passing off. The first statutory protection of marks was found in the late 19th century, criminal law sanctions of intentional copying and deceitful practices, and statutory protection in the current Trademark Act captures both civil remedies, of course, for common law passing off and some unfair competition torts, as well as new criminal sanctions for counterfeiting activities. We've suggested that undermining the use of use in our registration system pulls the rationalizing rug out from under the trademark system, but it also may pull out the constitutional rug from under the federal parliament. Like the US, patent and copyrights are expressly under the federal power, and while federal trademark legislation is not expressly provided for in terms of congressional power, it depends on its constitutionality on the trade and commerce power. So several cases have addressed the constitutionality of the provisions of the Trademark Act, in fact, the Act itself, and wherever it's been held to be intra vires, the court has pointed to the purpose of the provision. It's to round out the federal scheme, to nourish the federal scheme. And so we see then in these cases that this really is something that's contingent on the trade and commerce power. So rounding out a federal scheme that protects goodwill and ultimately prevents confusion in the marketplace. So this is the constitutional equation. It's unclear whether the if-then logic could follow in a post-amendment scheme that protects registered marks rather than marks in which goodwill resides. To be constitutionally valid, the codified protection against passing off, 7B, was read down to apply only to trademarks as defined in Section 2 of the Act. In other words, trademarks that are, by definition, used to distinguish source. The Act as a whole was found to be a constitutional exercise of the trade and commerce power in 2005 in Kirkby. A determination that we suggest may once again become suspect if marks are protected in the absence of actual use. The use requirement in Canada's trademark system is rooted then in the constitutional limitations on the federal trade and commerce power. Pulling up the roots may leave bare that claim to power. Nor is the constitutional issue reducible to the technical matter of the federal jurisdiction. There may also be charter-based problems for the new regime. In the absence of use, registrants can continue to accumulate signifiers, obtain injunctions, and monopolize meaning without ever engaging in trade activities that actually advance the underlying objectives of the regime. In the absence of trade, unused registered marks are essentially propertized commodities carrying with them rights to exclude and to silence the commercial speech of legitimate users and other public actors. And we suggest without any countervailing speech interest to justify such a limit. Where freedom of expression has been raised before the courts, they have referred to the Trademark Act's internal limitations to find that it minimally impairs freedom of expression. That is, it's a justifiable limit on speech. The concept of use has helped to ensure a rational connection then between trademark protection and the purposes underlying the trademark law. A rational connection to a legitimate purpose and minimal impairment of rights are necessary under the Charter to justify imposing limits on freedom of expression. Without limiting protection to marks that are used in fact in trade, the limits on speech imposed by the trademark regime may not be justifiable, and then therefore making the revised act vulnerable to a charter challenge as well as a federalism challenge. The trademark as source identifier is privileged expression favored over the misrepresentative, confusing, or misappropriated speech of third-party traders. But in the absence of use, trademarks have no communicative value, and the registered trademark owner does not actually speak. While limiting commercial speech might be a justifiable intrusion in light of other democratic goals, including promoting fair and free competition in commerce, protection in the absence of trade fundamentally changes the constitutional equation. Even if we set aside questions of constitutionality and rights and think in purely theological terms, we might ask what kinds of incentives the new regime will put in place and whether they will encourage the kind of communicative commercial activity that we actually value. A mark's intrinsic tellus, we might say, is to fully mature into a functioning sign in the marketplace. Professor Weber warned years ago, explaining the use requirement, there's really no good reason for a trader to sit on an unused mark. Blocking competitors getting into the business of selling marks instead of goods is what would result. Such activities ought not to be encouraged, and until now the system refused to reward such undesirable behavior. But now it will, and a predictable list of attendant aggravations will inevitably ensue, as we set out. The absence of a use requirement for registrants creates the potential for trademark squatting, similar to the domain name cyber squatting that marked the growth of internet commerce. Anticipating a future entrant into the Canadian marketplace, an applicant could secure registration of a trademark and sit on it until maximum value can be extracted from the would-be owner, who may have invested in acquiring rights abroad. The amendments thus produce a new motivation for trademark trolling. And in a system where valid rights flow from registration, it's not even clear that such strategic registrations could be condemned as bad faith. That was premature. Without use as a precondition to registration, Canada may also suffer the negative effects of trademark cluttering. The register could quickly become cluttered with unused marks, registered in association with an extensive, indiscriminate list of goods and services as strategic placeholders on the register. The most expansive statements of goods and services are likely to come from the applicants with the deepest pockets, and the predictable consequence of this, beyond trademark exhaustion, is a distributional inequality that subordinates the smaller, unsophisticated user against the large and lawyered up. The increased ease with which foreign traders may register and protect marks need not translate, in addition, into more or better wares or services offered to Canada's buying public. So trademarks in transition, then, also captures the larger picture, the changing nature of trademarks and the currents of global change and consolidation of trading capacity by large-scale multinational players. International pressures pointing us only and unremittingly in one direction, towards easy and efficient registration for international corporate actors, the availability of legal protection without the burdens of actual use. It's a nice gig if you can get it. In the domestic picture, at least, for the more powerful actors who may stake a position in such policy debates, early and easy protection is also preferred. Why support a use before registration requirement when foreign owners are permitted to register their marks without use in Canada? So, the interests of consumers, the public, and those committed to a use-based system are unlikely to hold their ground in the face of this push. If this spells the future both for Canada and the common law world more generally, then two questions present themselves. It's interesting to ask whether the US position requiring use in commerce, pretty well for everything but foreign registered marks less than 5 years on the register, is sustainable in the long run. Can America remain the last bastion of the use-based system, or will the global trend towards harmonization eventually sweep it up into a registration-based system? It's interesting, the US lawyers we spoke to thought it might, and it should. The legal academics thought, no way, and well, hell no. In any case, can we in Canada and across the common law world hold on to our traditional justifications of the trademark system, based around the protection of goodwill and the interest of encouraging fair trade and protecting consumers from misrepresentation and confusion, ultimately? Or is this now a false story? a misrepresentation about trademark law. If we are inevitably moving to a primacy of registration system on a global scale, even the word trademark, however you want to spell it, no longer tells a true story as to source of the rights it represents. It's actually deceptively misdescriptive, if you will, of a system that seeks to protect not the association between a mark and the trade source justified on the dual purpose of consumer protection and fair market competition, but rather one that protects the first to file in a bureaucratic machinery that privileges the well-resourced and stymies actual use in trade and compounds distributional inequalities. In this landscape, the trademark is the commodity. The registration system will take signs devoid of communicative significance and imbue them with legal significance. It's a recipe for predation. So I'm wrapping up 1 second. For trademarks to act as communicative symbols, they need to communicate a message for which they need an audience, a speaker, and a listener. Without use, there's no communicative act. With no communicative act, there is little, we think, by way of charter justification and no federal constitutional jurisdiction for the restraints or demands imposed by the federal trademark system. Our discussion here has sought to highlight some of the conceptual dissonance of the proposed system with its historical, constitutional, and judicial rationales as the marks evolve from powerful identifiers or trade source to simple vehicles of owners. And we have to ask, what are the interests of the non-owners, corporations, and other citizens, and how will they be preserved? How should we minimize the pains caused by such marks? So there you have it. Those are the pains, and I'm going to pass it on to Florian to expound on the pleasures and convince us of the pleasures of the system. So, thank you.
Our next speaker is Professor Florian Martin-Bariteau from University of Ottawa. Continuing on the discussion of use and registration, he'll be speaking on disrupting the myth of a Canadian paradigm shift.
Thank you. Thank you very much. So my comments will build on my PhD thesis that I successfully defended last December, and that was titled, one could say boldly and ambitiously, Rethinking Trademark Rights, and that study the new EU and Canadian framework. But I would like to begin my presentation stating the obvious. So I'm French. This implies two disclaimers. First, sorry for my French accent. Secondly, being French and having initially studied IP in France, I was taught in a jurisdiction of registration, not use. And moreover, I was taught by civil scholars who tend to deny trademark qualification to anything that is not registered, even though I argue the contrary in my dissertation. And I think that might explain why I'm not that disturbed by the 2014 reform. Indeed, the reform comes from the EU C8 and the EAP 2014 Act were in fact implementing CETA way before it was actually signed and approved. Canada decided to address EU concern and request in its trademark framework, especially regarding registration and GI, as discussed earlier. Sorry again, GI is because of French people. Indeed, CETA negotiations pushed for an approximation of Canadian and EU law, especially regarding trademarks. It is worth noting that at the same time, EU was also reviewing its own framework, a review that led to a new directive and a new regulation in December 2015. Both jurisdictions have today kind of a similar understanding of science and their protection, which in a global and digital world is not necessarily a bad thing. As to the changes, of course, we have been told that such changes were required by international law and a necessary step for Canada to integrate into the Madrid system and thus offer international registration. However, in my opinion, the argument is not convincing. As it had been told before, I would refer you to the US law as a counter-argument that did not require such a change to become part of Madrid. The current rules governing registration are quite similar to those currently in force in Canada. The Landmark Act simply provided for an alternative registration procedure where holders of an international registration can apply for US trademark without demonstration of prior use. Canadian law could have accommodated such a regime. Let's be clear, I wish that Canadian government would have discussed the reform, although regarding that change, I argue that if there is any paradigm shift, it's more a philosophical one, understood through a formalistic way than a practical one, understood in the functional manner. Certainly, Canada is a jurisdiction of use, and use is no more prerequisite. Nevertheless, it should be borne in mind that Canadian law already permits the registration of a mark without prior use on the basis of a proposed use. In my opinion, the new scheme merely removes the formality of the declaration of intent to use. The result of that, as before, an applicant may apply to register a proposed mark. What is different is that there are no longer separate requirements for such an application. I will discuss the issue on enforceability later. It should be noted that the change is quite actually restricted, especially as to the type of sign and in time, making the shift quite residual. Only inherently distinctive signs are registrable as trademarks. The new registration scheme provides that further evidence will be requested for all non-traditional trademarks to demonstrate actual distinctiveness, or to prove that distinctiveness as a filing date of application, with acquired distinctiveness through prior use. Indeed, CIPO had always attributed particular significance to distinctiveness, so the analysis of a mark's ability to fulfill the function of a trademark should and would remain equally rigorous. In my opinion, it means that signs consisting solely of a color, a combination of color, of a shape, a sound, taste, a texture, will require prior use for registration. Consequently, only intrinsically distinctive traditional verbal or figurative signs that depart from the industry habits and expectation of the relevant public may be ab initio registered without prior use. Moreover, the requirement of public recognition of the mark has been retained to allow trademark rights to survive. Within 3 years, it will be necessary to demonstrate to CIPO or any interested third party that this sign has been used to fulfill the function of a trademark in relation to the relevant public. The same could have happened with proposed trademarks. Admittedly, under the current framework, registration will not be perfected until the use of the mark commenced and a declaration of use is filed with the register. While under the new system, during the 3 years initial periods, the trademark right will be enforceable. Critics have suggested that this will allow parties to stockpile trademarks since there is no front-end check of the registration of marks that have not been used. On the other hand, that grace period could allow new projects to develop while being protected by trademark law in order to acquire the necessary reputation without any risk of big corporation stepping in. Certainly, in theory, a person will nevertheless be able to reserve the use of a mark in relation to certain products and services for 3 years to block competitors. But I will tell you, even those 3 years of protection are quite precarious. I would invite you to look at the US case law. US courts have considered trademarks abandoned before those 3 years statutory periods in case where there was no intent to use the trademark. Similarly, in 2014, the TTAB, the Trademark Trial and Appeal Board, confirmed the cancellation of a trademark registration due to a finding of abandonment before the period of 3 years, due to a lack of intent to use the mark for the goods and services as registered. So it's my opinion that the Canadian trademark system has certainly been modified and simplified by a single registration basis, the proposed and actual use of a mark as a trademark. The ability of a mark to fulfill the function of a trademark remains, in my opinion, central. Even the use remains central. Ultimately, the reform results in a registration regime that is relatively similar to the one in the EU or even the US for international trademarks, for that matter. And in the EU, we didn't see the abuse of registration that everyone is carrying for Canada. Mostly, in my opinion, thanks to the work of the examiners at the EU IPO. And the new act, as the current Canadian Act, provide SIPO with the same great powers to avoid abuse. SIPO should use it. You know what? Because as you know it, with great powers comes great responsibilities. So, in summary, I would say, don't be afraid. Everything's going to be all right. Thank you very much.
Our last speaker will be Mr. Robert McDonald from Gowling, who will be speaking on From Use to Registration, a Practical Perspective.
I was a little intimidated by my co-panelists, especially listening to the constitutional issues. I'm not going to touch on them. There are many events that you remember as you grow older that sort of are defining moments in your life. I remember where I was and what I was doing when the amendments to the Trademarks Act arrived in my email inbox. I was in New York City. I was in a bar. I was having a martini with a colleague, and we started to read the amendments, and I can assure you that it took more than one martini to get through them and truly understand what the government had just done without any consultation. However, as you settle in, as you go through and start to think about it, it's not that bad. The world is not going to come to an end. We will adjust. Life is going to be a bit more complicated, but we will adjust and move forward. That is my premise. I hope I'm right. So the fundamental proposition in our current act, as you've heard, is the concept of use. And what flows from use is an exclusive right that's given to you by the statute under Section 19. That section says the registration in respect of any goods or services, unless shown to be invalid, gives to the owner the exclusive right to the use throughout Canada of the trademark in respect of those goods and services. So what flows from that? Well, you can stop somebody from using the identical goods on the identical services. You can also stop somebody from using similar goods on similar services under Section 20 and the confusion provisions of Section 6. And those two sections don't change, essentially don't change. But your exclusive right is defined. It's defined by the use, whether it's use in Canada or it's use elsewhere. That's not to say you can't allege confusion beyond those goods or services. You can. But as we know, and as we've seen in the case law, the further afield you go, the more difficult it is to prove confusion. So that's our concept. That's what we've lived with for decades. Now, in theory, and this is, I think, where we get into some interesting issues, in theory, a foreign registrant can take action to enforce its registration in Canada, certainly within that first 3-year period, without any use of the trademark in Canada. A Canadian registrant can't. but a foreign registrant can. I say in theory. Well, in fact, Reckitt Benckiser versus Jameson in the Federal Court of Appeal in 2015 involved a registration that had been obtained based on use and registration in the United States. It had not been used in Canada. And Reckitt Benckiser was able to get an interlocutory injunction, parenthetically the first one granted by the federal court in about 20 years, able to get an interlocutory injunction which was upheld by the Court of Appeal. The registration had not been used here, but of course the registration was defined by its rights in the United States. I won't go into the case. The case is really quite interesting. I think at the end of the day, the judge really didn't like Jameson, but that was a different issue altogether. So the plaintiff wasn't enforcing an undefined registration. And in fact, the plaintiff could show a legitimate intention to enter the Canadian market. And that's one of the reasons the judge didn't like the defendant. Jameson knew about those intentions. So you have a situation where a foreign registrant can enforce today without use in the Canadian marketplace once its registration issues, but a Canadian registrant can't. Of course, after the third anniversary, the mark is vulnerable to cancellation. And again, the Federal Court of Appeal in 2015 dealt with, or in 2016, the Gouverneur versus One Group case dealt with a U.S. registrant who was struggling to get their mark into use in that 3-year period, wasn't successful, but was able to show special circumstances to maintain the registration. So that's sort of our current scenario. Your use defines your scope of protection. You know the owner has a true interest in the mark, and you're not dealing with a registration that is simply obtained for offensive or defensive purposes. And so we have change. At some point in the future, 2019, the Act will be amended. The amendments will come into force, and you will no longer need use to get registration. And in that respect, we come into the same league as most of our trading partners. Although that, having said that, just because everybody else is doing it doesn't mean it's right. I look at the United States system and I think it's a nice balance. You know, you can get your registration without use, but to renew, you have to have use. Unfortunately, or fortunately, however you look at it, our trademarks office got out of that business a long time ago when it stopped asking for specimens in support of an application. And our current system really does complicate things for foreign trademark owners. As a practitioner, I can't tell you how many times I've had to explain to a foreign registrant, no, we simply cannot file based on your foreign registration. We need to know, are you using? And what are you using on? It does complicate the process. It does slow down the process. And I'm sure there are lots of foreign applicants who simply say, enough of this, I can't figure out what to do. However, the danger is that what we will end up with are exclusive rights granted under Section 19 that are no longer defined by use. And that means we face a situation where trademark owners are enforcing their rights, which may be extremely broad and totally unrelated to their actual intended use. But let's keep in mind that can only be for the first 3 years, because after the third anniversary, that registration becomes vulnerable. Think about this. There are currently sitting in the Trademark Office database 50,000 pending allowed applications, 50,000 that are waiting to go to registration. They're waiting for a declaration of use. When the amendments come into force, those marks will go to registration upon payment of a fee for everything that's covered in them. And you might say, well, how big of a problem is the scope of those registrations? And I just looked at the Trademarks Journal yesterday, as one does. You just read the Trademarks Journal on a rainy Sunday afternoon. There was a trademark, pharmaceutical mark, which covered 70 different pharmaceutical indications, 70. That is not uncommon in the pharmaceutical sector. When it issued to registration, it was an old Trademarks Journal. When it issued to registration, it covered 2. Similarly, I found another application that covered, I think, 25 different categories of goods in multiple classes, but at the end of the day, when it issued to registration, it only covered 3. So people do file broadly, and they do file broadly, and they have to figure out what their actual intent is as they work through the process. It may not be clear at the beginning of the day. And so we will have all of these marks issuing to registration. Now, as has been pointed out, at the application phase, you can oppose on the basis that the mark is not in use in Canada or there's no intention to use the mark. That's a very difficult allegation to prove. From experience, I can tell you it's often pleaded, but seldom proved. But think about this. When you get to expungement, when you get to Section 18 and challenge a mark, non-compliance with Section 30 is not a ground of attack. The grounds of attack are very specific in Section 18. It does not include non-compliance with Section 30. You would have to proceed on the basis that there's a fraud been committed on the Trademarks Office. Also, a very hard thing to prove. So, where does this leave us in terms of new applicants coming into the country? When you look at it, you think, oh my God, the doors are going to open, the floodgates will open. Well, maybe they will. But Canada still has very arduous requirements for your application. You still need to provide a very specific statement of goods and services. And any of you who've ever worked through that with the Canadian Examiner will understand why my hair is gray at this point. It is a long and arduous process. Further, the Canadian government wisely has decided that there will be a fee per class, as opposed to, I heard it suggested at the outset, just one fee. So there are barriers to people who want to come in and say, you know, I'm going to cover everything in my application. But the key to my mind is, how will the courts deal with this? You know, we had the Reckitt-Benckiser case where the registration was in place, there was a bona fide intention to use, there were actual plans in place, and the federal court and the Federal Court of Appeal were both comfortable in granting an injunction to prevent Jameson from blocking the way, if you will. So now you have a situation where all these marks will go to registration. We will not know if they are in use in Canada or elsewhere without investigation. We will not know what the intention of the trademark owner is unless we can read their mind. I suspect we will see actions under Section 19 where it is simply, I own the mark for these goods, you're actually infringing, you're using that mark for these goods. It's very straightforward. And I don't see why the court would not grant the injunction, award profits. Damages might be difficult if you've never entered the market, but certainly award profits. And the good thing, we don't have, Professor Vaver was talking this morning about small claims proceedings. You know, we do have the federal court now letting us proceed by way of application, which is very fast and relatively inexpensive in the general world of trademark enforcement. So it's doable. But how will the court deal with a Section 20 allegation of confusion? Right? You've got to come in and prove the marks are confusing. And what are the factors that a court will look at in terms of assessing confusion? They will look at the extent to which you've used the mark. They will look at the extent to which the mark has become known. And if you've got no use, and the mark isn't known at all, then going farther afield than just your registration and just the specific goods in question will become more difficult. In fact, you may just be putting on the record all the reasons why your mark will be vulnerable to cancellation at the third anniversary. So will we see a wave of trademark owners enforcing in that 3-year period? We don't see a wave of foreign registrants currently enforcing in that 3-year period before they brought the mark into use. So I'm a little skeptical. But that doesn't change the fact the registrations will be there. And so you have a situation in which life is going to become more complicated for trademark owners. You know, when the government says, as it did, a regime that is aligned with other jurisdictions will also lower the cost of doing business to the benefit of both Canadian businesses and those looking to invest in Canadian markets. You know when the government says that, it's not right, right? And the simple fact is, it just got more expensive. How do you advise a client on their availability to use a trademark in Canada when you look at these registrations that cover everything under the sun? Well, you can't. All you can do is say, the mark is there, the registration is there, we can't find use, so for the next 3 years, it's speculative as to whether or not you're safe to use in Canada. It's going to become more difficult, it's going to become more costly. I mentioned that our Canadian Trademarks Office does not actively police the register. It's not its job, fine. But cancellation proceedings are expensive. They are time-consuming. In theory, they are a very simple procedure, and the cases have told us over the years they are summary procedures intended to clear the deadwood. And yet, they end up in the Federal Court of Appeal, in the federal court. They take, I think, the current backlog in the Trademarks Office, and I don't want to be called out for being wrong on this, but I think once your case is ready for decision, you have a year's wait for the decision. But meanwhile, you're in business. Life keeps going on, and you're waiting for this decision. So it will become more complicated. My advice to trademark owners today is, yes, you can rely on your common law rights. Yes, you have Section 7B. Yes, you have common law passing off. Yes, you do. Don't do it. Get your registration. Stake out your ground, because the cost of getting registration is minimal compared to the cost of litigating, the cost of canceling, the cost of opposing. And all of those things, I think, will increase. So there's a lot of work to be done between now and whenever the government brings the amendments into force. There will be lots of work after implementation. And as with so many government amendments, the lawyers are going to be very busy. Thank you very much.